Hello friends, welcome to Business, Labor and Tax Laws with Satish. In last presentation video, we have seen about the ESI benefits, its consequences and other things. This video I specifically brought about Maternity Benefit Act related to adoption, commissioning mother and other allied benefits. Come, let us enter into the presentation. So first of all, we would see the applicability to who under this maternity benefit would apply. So any establishment, including factories, mines, shops, establishments with 10 or more employees, it covers both public and private sectors. In public sector, like state governments and all, they have even a better scheme than this. So when the better schemes are there, that apply to them. So this prescribes only a very minimum things which need to be complied of. So if somebody is already providing a better benefit, they will be governed by that particular prevailing rules. So next we will go into the eligibility for the maternity leave. And from here onwards, I am switching off my cam. So the eligibility for the maternity leave, a female employee is eligible for maternity leave if she has worked in her current organization for at least 80 days in the 12 months immediately preceding the date of her expected delivery. So this is the very eligibility which the woman should comply with for her to claim the maternity benefit. So the duration of the maternity leave, earlier it was 12 weeks. So from 2017 there was an amendment which now they are providing 26 weeks, which will be almost 6 months. A paid leave will be provided, and this includes 8 weeks before the expected date. We generally call that as prenatal, postnatal. So woman, if she wants, she can take it on a prenatal basis, 8 weeks. After delivery, the balance 18 weeks, or else the whole 26 weeks after the delivery also she can take. So the payment during the maternity leave, during the period of maternity leave, the woman is entitled to receive her full wage or salary. The employer cannot reduce her pay or discriminate her in any way. So it is not only that, even employer cannot dismiss her or terminate her since he is availing the maternity benefit. So that protection is also being given under this Maternity Benefit Act. So the benefits, in addition to the paid maternity leave, the woman is entitled to maternity benefit which is calculated at the rate of her average daily wage for the period of her actual absence. In addition, they are also entitled for the mandatory medical bonus of rupees 3,500. This is also a latest amendment. Earlier it was some 2,500 and all. Now it has been enhanced to rupees 3,500. And as I said earlier, there is a protection from termination. Since some woman employee is going on a maternity leave, the employer cannot terminate her. So this act provides even the protection from the termination. And at the verge of the delivery time, even she can ask for the very lighter work. So the employer not to provide any arduous, very hard work to the woman. So such protection also encompassed in the Maternity Benefit Act. So an employer cannot terminate the service of a woman during her maternity leave or due to her pregnancy. Doing so is a violation of law, and he will be liable for the penal action also. And then the crush facility. Once after the maternity leave is over, when the woman employee is joining the establishment, she can bring her child and she can leave it at the crush facilities. So this is also being mandated in the act. So this applicable whenever the establishment is with more than 50 more employees. This does not say the 50 employees should be women. In total, if the employees strength is more than 50, then the organization has to create a crush facility. So there should be a caretaker, there should be some toys, milk, and the cradle, other things, so that the child will be taken care of. And the woman employee is also entitled for the nursing break, which I will touch upon the subsequent slides. And no night shift, she can avoid the night shifts, and she may continue to work on the day shifts with all the nursing breaks, lighter work, all these things. So you might have seen I have put actress Nayanthara photo in the first slide. You might be thinking, what is the connection? Actually, she is a surrogate mother who does not give her childbirth on her own, but she got the child from the surrogate mother. So even the surrogate mothers, adoptive mothers also entitled for the 12 weeks of maternity leave from the date of getting the child on their hand. Apart from that, this act also provides 2 weeks leave for the tubectomy and 6 weeks leave for the miscarriage or any termination of pregnancy also. And this act prescribes uh, formal information to the employer. Even if she fails, it will not affect her entitlement to claim the benefit. So that's why this is an act for advancing the social welfare and social protection to the woman, which will not stop her career progress in comparison to the in comparison to her men colleagues who are working in the same establishment or organization. And the format how to inform the employer I have attached in the subsequent slides. And apart from that, this act also uh, mandates the employer to maintain some records. Okay, uh, when the amount, how much women employees were employed, how much maternity benefits they are given, the amounts which has been settled to the woman employee, when she applied, when the payments are made, all these records as an employer has to maintain. And any non-compliance will attract the penalties. So as I said earlier, this is related to nursing break. Every woman delivered of a child who returns to the duty after such delivery shall, in addition to the interval for rest allowed to her. So this is in addition to the normal rest. In general, any employee is entitled for 2 tea breaks and 1 lunch break. So apart from that 2 break, she is entitled in addition uh, for for those breaks, from those breaks, these 2 breaks. So that is 15 minutes plus 15 minutes plus to and fro whatever she travels to that crash to feed the baby and return. In addition, some 5 or 10 minutes can also be allowed for her by the employer. So this is one recent case law wherein when a woman employee is submitting her form for claiming the maternity benefit at the verge of her contract ending period. So the company, in general, earlier they used to stop. For an example, if her contract going to end by December, she is submitting an application by October. Then the 3 months alone the company would pay. But in this case, Supreme Court has directed and has ruled in favor of the woman employees that the whole 6 month need to be paid. So even such benefits exceeds the terms of the contract. In the example which I cited, even though her contract going to end by December, she is entitled for another 3 months. So the next year, January, February, March, she will be entitled to claim the maternity benefit. This is a very advanced judgment to support the cause of the woman and in favor of the woman employees. And there is one section in Maternity Benefit Acts which talks about maternity moonlighting. So this talks about generally moonlighting means the employee may work in two organizations simultaneously. So similar provision is in Maternity Act also, wherein woman avails some maternity leave from one organization. If she opt to work in some other organization in that leave period, then she will be disentitled to claim the maternity benefit. So there would be a forfeiture of the maternity benefit. This is also encompassed in the act. So this is the sample notice how you should give. When if you refer Google, there are a lot of forms, but this is a very statutorily prescribed form. So those who want to use may use this. This is a very simple format. It is available in net also, internet. You can take and make use of it. Otherwise, those who wish, even you can write and submit by taking a screenshot of this. And in Tamil Nadu, if you see, there were commissioners notified for this uh, specific purpose of enforcing these provisions. So they would be the inspectors of this particular Maternity Benefit Act. In case of any grievance or any non-compliance, those women employees are entitled to raise a complaint or petition before this inspectors. And thank you. Kindly like, share, and subscribe. Thanks for watching this video.